State of Arizona versus Francis Cruz Mendoza-Keel first. That's CR 2025-00513, and this is the time set for a trial scheduling conference.
Reverend Kent for the state.
And Daniel Hartman-Strong for Mr. Keel, who appears present in custody.
All right, thank you.
And Barbara Vogel from Victim Witness Services for the victims, appearing via Zoom.
All right, thank you. And this is the time set for trial scheduling conference. The defendant has indicated that they would not waive time at the last setting. I was just looking in terms of Rule 8 time. The only time that was not previously excluded was the time between arraignment and the first case management conference, which was 27 days. And then most recently, since the defendant indicated he wanted a trial on the day that he was found competent on January 12th through today, so an additional 15 days, a total of 42 days. Is that what the parties have?
Yes, Your Honor.
Your Honor, it's actually slightly more than I had. I think are you calculating both between arraignment and Rule 11 and then from the date of the 12th until now, basically?
Correct.
Okay, that's what I have, Your Honor.
Okay, and so then with that, there are 108 days to set the matter pursuant to Rule 8. And which really just leaves the court with a single date that I'm going to tell you when the trial is going to be. But how many days do the parties anticipate the trial being?
We discussed, and we think 2 days is sufficient.
That's correct, Your Honor.
All right. And what is Mr. Mendoza-Keel's exposure if convicted of all counts?
Sorry, Your Honor. So, he'd be Category 3 at trial. There's 2 different Class 4 felonies that could run consecutive. So, he could be looking at up to 30 years in prison.
All right, so we can get to 30 years, so then it would be a jury of 12 with 1 alternate. Do the parties agree that 1 alternate would be sufficient with such a short trial?
Yes, Your Honor.
Yes, Your Honor.
All right, you both agree that it's a 12, that it can go up to 30 years?
Yes, Your Honor.
All right. All right, the trial date, I will just tell you, is going to be March 17th. On that day, we're going to start at 1:30 and we're going to go to 5 o'clock on the 17th. And I'm going to schedule it for 2.5 days if the parties think that 2 days is sufficient. I'm going to do 2.5. So 1 day for jury selection and openings, hopefully, and 2 days of presentation of the case in chief and any defense case. The court on the 18th and 19th, we will go from 8:30 to 5 o'clock. The comprehensive pretrial conference date that I would usually use would be February 19th, but I'm concerned as to whether or not that's too soon for the parties. Where are you with your interviews?
Your Honor, we have not begun anything yet for the pretrial process. I'm in the middle of a trial right now that resumes at 1:45, but I can start those next week.
I'm going to be out of the office the week of the 19th, but I believe there will be a total of 3 defense interviews that will need to be done here. State only plans on calling 3 witnesses.
All right. Mary, can you look on our calendar? Do we have time the following week on February 26th?
Yes, we have time on February 26th at 1:15.
Can the parties do that day?
Yes, Your Honor.
Yes, Your Honor.
All right, comprehensive pretrial conference will be at 1:15 on the 26th of March. At the comprehensive pretrial conference and motions hearing, the court will discuss with counsel the survey monkey that will be distributed to prospective jurors and trial logistics. At the comprehensive pretrial conference and motions hearing, the court will also hear all pretrial motions, including motions in limine. If a party wishes to present evidence in relation to a pretrial motion or motion in limine, that party shall be prepared to present such evidence at the comprehensive pretrial conference and motions hearing. Oral arguments will also be presented at this hearing. The deadline for filing of pretrial motions I would ordinarily be setting that right now as the deadline. The parties, you believe that you'll be able to accomplish those 3 interviews next week, is that correct?
I think that's possible. I would defer to defense counsel.
I'm out of the office Thursday and Friday next week, but as long as this, 2 of those witnesses are police officers and the third is additional witness, I think the state would procure. So I would defer to the state whether they can make them available basically Tuesday or Wednesday.
I'm going to set a deadline for the filing of pretrial motions, including motions in limine, of February 13th at 5:00 p.m. So that gives you a little bit of leeway, but you're going to have to work out your own deadline for getting your interviews done and your motions into the court before that deadline. Response and reply time is just going to be in accordance with the rules of criminal procedure. I'm not going to set a deadline again for witness interviews because we're already past the time that the court would expect those to be done in a normal time frame. The parties haven't started those knowing that the case is set for trial, so I'm leaving it on all of you to get that done at this point. The deadline for filing information to be included in the SurveyMonkey will be 1 week prior to the comprehensive pretrial conference and motions hearing. So that will be on February 19th at 5:00. By that deadline, counsel shall file with the court the following items: a statement of the case that's been agreed upon by both counsel. Secondly, all proposed voir dire questions that counsel wishes to be included in the SurveyMonkey. Each side's limited to 15 voir dire questions for inclusion. The court will include in the SurveyMonkey all the standard voir dire questions from the Arizona Office of the Court's Criminal Trial Bench Book. Counsel will have the opportunity to ask additional questions during in-person voir dire. Third, a list of all attorneys who are working in each counsel's office as of that date. Fourth, the name of all witnesses that counsel intends to call at trial. Fifth, the name of the case agent. And sixth, the name of any investigators or co-counsel who will accompany counsel at the trial at counsel's table or before the bar. At this time, the parties haven't participated in any settlement conference or really most of the time of the case has been occupied by the Rule 11 proceedings. Is either party asking for a settlement conference as we're pending trial?
The state is not, Your Honor.
And Your Honor, we are not requesting one. However, I would ask that a Donald hearing take place today.
All right, let's do that. The parties, if you would, Mr. Kent, you indicated the range, the maximum range that you believed. So as a category 3, count 1 is a class 4 felony, so the maximum term for that is up to 15 years. And count 2, it's also up to 15 years as a class 4 felony. And then the disorderly conduct 6 months and the class 3 misdemeanor is just up to 30 days of jail. So, Mr. Mendoza-Keel, as I look at the information, which is the charging document in your case, for both counts 1 and counts 2, you're facing a range of sentence in each of those that could go anywhere from a mitigated sentence of 6 years up to an aggravated sentence of 15 years. The presumptive term where I'm required to start, if you're convicted and the state establishes that you had 2 prior felony convictions at the time of the commission of the offense, that would put you into category 3 of this Arizona state sentencing parameters. That's the highest sentencing range that we have in Arizona. The presumptive term there where the court has to begin is 10 years on each of those counts. I believe I have discretion as to whether or not those would run concurrent or consecutive, but the court's free to run them consecutive, meaning stacking the 2 counts. The aggravated sentence that you could receive for that is up to 15 years. I would note that each count has a separate victim, which leans more towards a separate sentence for each victim, but the court does have discretion to run them concurrent. So that's the range that the court has available to it on each of those 2 counts. In reality, those are by far the most serious counts that you have here. On count 3, you're facing a charge of disorderly conduct.
Sorry, I made a mistake. These are actually charged as class 5 felonies. I forgot about the change in the offense designation.
So the offenses in the information, it's incorrect, and it should have been as it appeared in the original complaint. When I was in justice court?
I believe so. The original complaint charged aggravated assault, class 5 felony, 2 counts on April 22nd. I believe at that point, those offenses were indeed class 5 felonies.
It says class 4s.
Okay. So that changes the range. I noted the difference between the complaint and the information. The information that was filed on the Superior Court was for class 4 felonies. The complaint originally in justice court had been for class 5 felonies. If they in fact are intended to be class 5 felonies, the range is slightly less. For each of the class 5 felonies, the range would be from 3 years to 7.5 years, and the presumptive term is quite a bit less. The presumptive term is 5 years on each of those. So the maximum that you could get is up to 15 years on those 2 counts. That does change the number of jurors that are necessary for the case and reduces that down to a jury of 8 rather than a jury of 12, because your exposure comes to up to 15 years on counts 1 and 2, 6 months on count 3, and 30 days on count 4. Do the parties agree?
I do, Your Honor.
All right. So those are the range of sentences that are at play during the time of your jury trial. Do you have any questions about that, Mr. Mendoza-Keel?
No, Your Honor. No, Your Honor.
All right, thank you. And the court wasn't privy to the plea offer that was made in the case, so I'll turn it over to the state to outline what it is that Mr. Mendoza-Keel is rejecting.
Your Honor, the state offered as a plea that he plead guilty to count 1 as a category 1 felony, so class 5 category 1 sentencing range.
So probation available?
No, Your Honor, probation would not be available.
Okay, so it's category 1 prison only.
Correct.
All right. Any other terms?
Don't believe there were any other terms.
All right. So the plea offer that was presented doesn't allege your prior felony convictions against you to put you into a higher sentencing category, but it is being treated as a prison-only plea agreement. The range available for that as a class 5 felony would be anywhere from 6 months of incarceration up to 2 years and 6 months of incarceration, and the presumptive term is 1.5 years. You, of course, get credit for all the time that you've been in custody pending up to the date of your sentencing. When you go forward today, you're rejecting that plea offer that was made to you by the state, and instead you're taking on the risk that you could be convicted and that the state could prove your prior felony convictions, and then the court's obligated to sentence you according to that range that I went over with you. Do you understand, Mr. Mendoza-Keel?
Yes, Your Honor.
Is it your desire to reject the plea offer that was offered to you by the state at this time?
Yes.
Is there anything else that the defense wishes to put on the record?
Nothing for me, Your Honor.
All right. Anything else that the state wants to put on the record?
No, Your Honor.
All right.
Not about that.
Your Honor, actually, if I could just put one thing on the record, we did have about 8 months of Rule 11 evaluation for various reasons in this case. And I just want to, I think we resolved this at the Rule 11 hearing, but after speaking further with Mr. Mendoza-Keel and with his second evaluator, Dr. Linsky, I did have serious reservations about Mr. Keel's decision to go to trial, in part because I know that spiritual guidance is playing a very large role in his decision-making instead of maybe my legal analysis taking the lead there, and that presents concerns for me. However, in light of the discussions I've had with Mr. Keel and Dr. Linsky, we are ready to proceed to trial.
All right. Thank you. At least 1 week prior to the trial, which is on March 17th, so March 11th is the day we're talking about, by 5 o'clock on that day, counsel shall file with the court and email my JA the following items. First, all proposed in-person voir dire questions. It doesn't actually have to be the specific questions, but the general areas that you intend to get into would be sufficient for that. Secondly, all requested preliminary jury instructions. You can just do that with a list using the usual preliminary jury instructions list without actually filing the instructions themselves. Third, also a list of all the final jury instructions that you'd like to have used from the most recent Raji. That would be sufficient on that. Third, all proposed verdict forms. And then fifth, any stipulations by counsel regarding the admission of any of the evidence in the case. Again, counsel are to use the most recent version of the available Rajis. All proposed instructions do not need to be sent to the court, but if you are asking for any changes to any of the instructions or something unusual, I would like you to submit that both in Word format with and without Raji or case law references. On the Friday before the first day of trial, which will be the 13th of March by noon, counsel shall file with the court and email my JA a list of all the prospective jurors that you have agreed to strike for hardship based upon your review of the SurveyMonkey responses. Is there anything? Those are all the deadlines that the court intended to set. Are there any other requests from counsel?
Nothing else, Your Honor.
Your Honor, I would move to amend what I believe is a technical defect in the information and change the felony level in counts 1 and 2 from 4 to 5.
It's granted, but I would like you to file an amended information that reflects the change so that there's a very clear record of that in the court's file, because the information with them listed as Class 4 felonies is currently the only information in the file. Understood? All right. Anything further?
Nothing from the state.
That will be all in that matter.